Well, good afternoon. It's me, Richard Bishop. I hope you're well. I'm just having a quick look at the article by Keith Richards that's just come out today. Very good article. Obviously, the Keith was the CEO of the PFS, so definitely worth reading what he's got thinking on his thoughts or what he's got to say. I'll just go through that. I'll go through at the end because the main reason for the video is about the Articles of Association of the PFS, which seem to be a huge contentious point at the moment. And I thought it might be interesting just to make sure everybody understands them or understands them from what I understand of them. And there's also this 2010, this sort of conspiracy theory, this 2010 conspiracy theory when members think that CII put this huge Section 3 in there with all these additional powers. And they did that in 2010 because they were lining all this up and this is what they wanted to do all along. So I'm going to go through that as well. So if we have a quick look, this is Companies House. You can see that in 2004, these ones here, that was, I think that's like it was an off-the-shelf company back then. We don't need to do it now because in 2004, we need the technology wasn't there at Companies House. So what the companies would do, they'd do the paperwork for 100 companies, put them on the shelf, and then you bought an off-the-shelf company, so you didn't have to go and do all the paperwork. So in 2004, in 17th September 2004, that's when the first set of articles were submitted to Companies House. They were then changed in 2007 and 2008. I can't really figure out. I think that one there is when the memorandum was missing. Maybe they just refiled it. As you can see, it was on the more or less on the same day. But anyway, we've got the 2004 articles, which were the original articles, the 2008 articles, which is 4 years later, and then you've got the 2010 articles, which don't appear on Companies House for some reason. I think it's just because it was filed incorrectly, but they are there, but not in the incorporation. So what I'm going to do is have a quick look at the original articles. And there's not many contentious points, to be fair. These articles of association gave the CII control over the PFS through voting rights, effectively, or because they could form a majority board. That was always in the 2004 articles. It was in the 2008 articles, and it's in the 2010 articles. There's no manipulation of the articles of association by the CII. That was how it was set up from day one. Obviously, a huge mistake. If you're doing that net today, then any legal advice would be to sit down and look at the implications of that. I mean, so for an LIA, I mean, it wasn't a small amount of money they put in there, 1.5 million, I think it was, up to 2 million in the end that actually went into the PFS. I mean, obviously they wanted the linkage with the CII. I get that, but it was a huge mistake in 2004. Because what they should have done was said, yeah, okay, well, you will be a subsidiary because you can have control of the voting rights. But these key points, then you'll rescind those voting rights. So things like winding up, sale, moving IP, moving assets, some of these key things that would affect the company, asset stripping effectively, although I'm not accusing the CII of doing that. What you would do is put those in the articles to say, even though you form a majority board, any major big decisions like this, winding up, etc., they have to be done on a 50-50 basis, equal shared basis. And that would have made it much fair. Well, obviously would have made it totally fair. And you wouldn't be even in this position because the CI wouldn't be able to form the majority board and make decisions that the PFS doesn't want to make. So, legal advice wasn't what it was in 2004. I'm not particularly... when I say it was a huge mistake, I'm not pointing fingers at the 2004 board or SOFA or LIA. It just wasn't like that then. Although we did have, at the time, there was a lot of demutualisation because that's why community interest companies and charitable incorporated organisations were developed to stop members, the manipulation of members coming onto a board and then moving assets out. That was the whole point of community interest companies, which if you set it up today, the PFS was setting up today, that's exactly how it would be set up, because it's got an asset lock in it. But unfortunately in 2004, they weren't available. So as I say, not pointing fingers, but it was a disaster. You can see it was if you just read this document today. So we then move on to the 2010. So this is the contentious point here. The 2010 Articles of Association are pretty much word for word the same as the 08 and 04 articles. They tidy them up a bit because we did in 2006, we went from the 1985 Companies Act to the 2006 Company Act. So the articles were tidied up because the 2006 brought in the new model articles. So you can see in Section 2, they adopted most of the model articles, but they excluded these here. And I've been through those. Again, there's nothing contentious on there. Some of it's conflict of interest and some of it's about forming quorums, because obviously the quorum, forming of quorum is different to the new model articles, but that's all that does. There's nothing contentious there. But what we have got here is Section 3, which is a big section. So you've got the company objects. Now, this did not appear technically in the 08 articles because they missed it out. This is why you've got that 07 and 08. It's missing. I'll come back to why it's missing, but it's a big section here and it's got powers basically that the CII need to do what they want to do. So Section 3.43, amalgamate with a company or organisation of objects similar to those of the society. So if the CII carries on in what it's going to do or proposing to do, as soon as it forms a majority board, then it can instigate Section 3.43 and put both organisations together. And of course, the assets will go together. Totally legal. You've also got here Section 3.46. So this is maybe a contentious point here where the CII are accusing the PFS of not following the articles, because they definitely haven't done. Because if you put to invest and deal with monies of the society not immediately required, well, they haven't been doing that. This is why we've got this massive surplus. And the surplus is causing the issue because allegedly the CII are implementing these actions because they want access to the surplus and they want to use that surplus in the CII. And again, that's perfectly legal. There's nothing wrong with it. The PFS members might not want it to happen. But unfortunately, legally, you haven't got a leg to stand on. There you go. So we've also got to lend and advance money to give credit on terms with or without security to any person, firm or company. The holding company, that'll be. So again, they could. They don't need to move assets out. They could do. They could advance money on no credit terms. Sorry, no interest terms. Or they could lend it on interest or not interest. So the Articles of Association here, these are the 2010 articles. There's lots of powers here, but the three powers we're looking at here in terms of the CII and what they're trying to do, allegedly, is if we can use Section 3.43, 3.46 and 3.47, it's all over. Form a majority board. We can amalgamate both of the companies, or we can invest the surplus how we think it should be invested, determined by the board. So the board would determine that, voted right, so they can do what they want with it. But they'll probably use Section 3.47 and they'll advance money to the CII. Nothing wrong with that either. So if we go back to Section 3, you can understand why, if you looked at 08 articles where these allegedly these Section 3 is not in there, this is where the conspiracy theory comes from. Because suddenly the CII have got all these powers put in there in the articles in 2010. And now they can do whatever they want to do. So I get the storyline. Problem is, it's not true, because what actually happened in 2006. In 1985, we had two documents for a company. You had the memorandum, and you had the Articles of Association. There were two separate documents, and the memorandum at the time gave the objects of the company, what they did, and the objects were restricted, and it gave the big general powers, which some of those I've just read out. So that was in the memorandum. Then you had the Articles of Association, which is like the rule book, just general rules. You could put, but it wasn't. The powers were put in the memorandum, the big stuff. What happened in 2006 is everybody, regardless, came under the new model articles. So if you got your own articles filed under the 1985 Company Act, then you could carry on with them. But the problem was the 06 new model articles didn't have a memorandum. So the companies that were formed prior to 2006 said, well, what's going to happen with my memorandum? And what happened in 06 was they said, well, we'll deem that the memorandum is part of the articles. You don't need to go back and put them all together, because it would have been a huge exercise for like 2 million companies to go back and get their memorandum and shove it in the articles and refile it. They said, we'll just deem it that the memorandum that you filed is part of your Articles of Association, and we'll move on. And that was implemented in 2009. So what happened here was, if we go back to the 85 articles, the memorandum is at the back. Here it is here. So it's a separate document, like I've just explained. There you go. So the memorandum's here. That was deemed to be in the articles. You didn't need to put it in the 08 articles when they put it in there. When they refiled the 08 articles, it was already in there. However, what they did in 2010 is they did put it in there, and that's good legal practice. That would have probably been some of the advice they were given. Well, if you're going to refile your Articles of Association, you want to tidy them up. So it includes the new model articles, which is exactly what they did. And they would have been given the advice to say, well, just, so it's not confusing to members, what you want to do is take the memorandum and actually put it into the articles, so it's job done. You got one document, and then you won't have to alter it again, which they never did. So what they did is they took the memorandum and they created Section 3. So Section 3 is just the memorandum of the Articles of Association. Sorry, the memorandum put into the articles. No conspiracy, nothing. They were already there, because the memorandum would have, although it wasn't in the Articles of Association in 08, it would have been deemed to include it. So that's where the all this what happened in 2010 story. I'm afraid, unfortunately, it doesn't stack up. The CII did nothing wrong. In fact, they did everything right, because what they did is they put it in 2010 so their members could read it. And maybe if the members had read it properly in 2010, some of them should have turned around and said, well, hold on a bit. Doesn't that mean that you can form a majority board and move assets out of the company? Yes. Well, doesn't that mean you can form a majority board and make loans or advance money from the PFS to the CII? The answer is yes. So, again, I don't think it's a bit unfair to say individuals are at fault. They're not. But the membership's at fault, because you should have read the articles in 2010. And if you did read them and voted for it, you ought to blame. I'm joking. But unfortunately, it's true. All right, we're going to finish off. I hope that makes it clear. So no conspiracy theory, 2010, perfectly fine. They just included the memorandum into the Articles of Association and tidied it up under the model articles because of the 2006 change. Although Company Act 2006, it was when the Act was done. It wasn't 2009 until all that kicked in terms of Articles of Association. So there you go. So I don't see anything wrong with the Articles of Association. I don't see anything that's been done underhand, other than the members should have actually, just to repeat myself, should have realised what on earth they were doing and what they were signing, and refused to do it. Or gone back to the board and said, we're going to be in real trouble here. The resolution there, it's pretty straightforward. That's exactly what happened. They tidied them up and included the memorandum, which was already there anyway. So I'm just going to finish up. If you wanted to actually stop the PFS, you'd be silly to do it, because the PFS couldn't actually, if the CII isn't allowed to do what it wants to do and goes and has monetary issues, it'll drag the PFS down with it. So all this idiocy on social media about taking over the CII, and forget about it. It's not going to happen, because if you do that and you try and you cause the CII too many problems, then or don't allow it access to money that allegedly it needs, then you're going to drag the PFS down with you. So we'd be careful about doing that. However, if you wanted to have a fight with the PFS, not that I would advise it, but if you did, you can make a petition to the court under Section 994. Just need to go and get a barrister or a solicitor to make the petition into the court, and that will cause a load of problems, because it will effectively, the company will be frozen. And you could also put in a petition you want to freeze the assets, the balance sheet, because you don't like what they're doing. Not that I recommend it, but you can. There it is there. A member of the company may apply to the court petition for an order under this part of the ground. On the ground, company's affairs have been conducted in a manner that is unfairly prejudicial to the interests of the members generally. I don't think anybody would argue that's true. So what you want to do is get your crowdfunding together and get a barrister and go and get your Section 994 into court, preferably the High Court, or maybe it would be the High Court. Not a lawyer, by the way. So there you go. So I hope that makes sense. Unfortunately, the articles are kosher, as they say. Nothing wrong with them. CII haven't done anything wrong with them. Is there any fault? Yeah, because the PFS members should have realised what they were doing. But, I can appreciate it's not that simple to understand exactly what they'd let themselves into. The other part, just to finish off, if the PFS members, the board directors, another way of crippling the company, this would totally cripple the company, is if all the PFS directors resign, then it's all over, because they won't be able to form a board. So they won't be able to do anything. Even if they've got a majority board, they won't be able to form a board, because they won't be able to form a quorum, because there's no PFS members. PFS directors. So there's your two options. All the PFS directors resign. All the PFS members agree none of them will be appointed a director, and go and file your Section 994. And that will cripple the CII and close the PFS, though, unfortunately, ironically. But there you go. I hope that was interesting. Drop me an email. It's richard@pfep.co.uk if you've got any comments, or you can comment below the video. See you soon. Bye.